Okay, the recording has started, and I have 4:09 p.m.
Okay, great. Please call the roll.
Member Hinsey?
Present.
Member Hinsey present. Member Yankee?
Present.
Member Yankee present. Member Highland?
Present.
Member Highland present. Member Schmidt?
Present.
Member Schmidt present. Member LaHood?
Present.
Member LaHood present. Member Wong?
Present.
Member Wong present. Chair Wolf?
Present.
Chair Wolf present. We have a quorum.
Okay, great. Okay. I just wanted to discuss the agenda for a second. In the item number 6, file number 19092, the task force in the in a previous meeting had mandated that the or ordered that the this case and another one. There was another case that was
19048.
19048 be heard, that both these be heard together at the time that this item was brought to the task force. It was overlooked at the upon creating the agenda, and by the time I was made aware of it, the agenda had already been posted. Now, the ordinance is clear that in 67.7 F, is it 67.6 F? I'm sorry. That in regarding special meetings, that special meeting notice of a special meeting should be delivered as described in section E, which is our regular kind of more or less the regular delivery, and at least 72 hours before the time of the meeting is specified in the notice. The notice shall specify the time and place of the special meeting and the business to be transacted. No other business shall be considered at such meetings. So we have to determine, and we'll ask Mark Price Wolf, our legal counsel, to chime in here too, whether we can consider to add that 19048, considering this is all part and parcel of the same issue, same cases, and because the task force had made the order to have these items heard together. So I'll stop there if people want to chime in, if they have any thoughts about that. Otherwise, we can ask DCA Price Wolf to chime in on it. Okay, Mark, can you help us out here?
Sure. So my thinking on it is sort of just along the same lines as the law on notice and agendizing items for public meetings. They serve a very important purpose, and I think you have to have enough information and detail enough so that the public is not caught unaware during a meeting, so that they can prepare. It does not have to be an extraordinary level of amount of detail. But especially, I think, when there's a special meeting set, you really need to make sure that what's included in the agenda is what the meeting is, what the participants are going to speak about, and so that the public can be informed and be prepared too. So my thinking is that I think that to frame the task force discussion around what the issues are that are going to be addressed in the current agenda under the current complaint that's noticed. And my understanding is that really is, if, as Chair Wolf says, that the issues to be discussed are essentially identical in both complaints. These issues of the extent to which the zoo is governed by the full panoply of the Sunshine Ordinance, or maybe just different parts. Like, if that is in fact true, then really leaving out, the fact that another file number is impacted, I don't think is very substantive. But if maybe certain aspects of one complaint are not part of another complaint, and you're going to end up necessarily needing to talk about the one complaint number that wasn't properly noticed, then I think you're getting into an icky area where it should have been proper. Then the fact that it wasn't specifically noticed is not giving the public a fair chance. So I know I'm sort of talking in theory here, but what I'm hoping to do is if you can comfortably set ground rules ahead of time, that the only issues that you're going to be discussing are those that have 100 complete overlap in both file numbers, then really there's no disadvantage by not putting in the agenda the exact second file number. So I'm talking parties, issues, the whole nine. So I think that's where you guys should frame your discussion about whether you're comfortable hearing both matters today. If there's any concern, you err on the side of abundance of caution and just put it over. But I think that's how to think about it today. I'm happy to answer questions on that, but that's how I think you guys should frame your discussion.
Thank you. Members, what shall we do?
I'll speak. This is Member Yankee. If I recall, the one that was on the agenda for today was essentially an additional records request after we ruled favorably in the first file number that was not included in the agenda. And I believe to Mark Price Wolf's point is I believe they were both focused on basically does the lease between the zoo and the city make the zoo subject to the Sunshine Ordinance. So I think the issues were the same. It's just the second request was an additional set of records that were requested. And we've already ruled in both cases that there was a violation. So I'm tending to think that it would be okay to continue, but that's just my initial read on it.
You mean continue in this meeting or continue?
Yes, to continue with the hearing in this meeting.
Okay, great.
I don't know if the other members agree.
Anybody else?
I think what might be helpful, Matt or Bruce here, is if you could just briefly summarize, like you kind of did, Matt, just say, because I can't remember which is on the agenda and which is not, and just say, file number X, this was the main issue. That one is on the agenda, file number Y, this is the main difference. I just can't remember which is which on the agenda.
Sure, I could do it. So file number 19048 was the original complaint, and it was a records request for various records from the zoo. The main dispute was, whether the zoo was subject to the Sunshine Ordinance, and if I recall, there was a lease produced, and that lease specifically said that the zoo would be subject to the full Sunshine Ordinance. And so we ruled in favor of the complainant. After we did so, he filed a separate records request that was subsequently denied by the zoo. Obviously, then he brought that to us as file number 19092. Same issues, just additional records after we received a first favorable rate ruling from us. Does that help?
I think for purposes of this case and then future cases, I'm looking at there's an identity of issues and also there's an identity of parties here. So this seems to be that kind of case where I'd go along with what you guys are saying.
I just wanted to reference our March 4th, 2020 meeting that for file number 19048, the action was to, there was I'll just read some of the narrative. It says, upon discussion, the task force opined that file number 19048 should be scheduled to be heard at the same time as file number 19092 is scheduled before the task force in order to provide all aspects of the issue to the Ethics Commission and the District Attorney at the same time. So the action was moved by Member Yankee, second by Member Hinsey, to continue the matter to the call of the chair and request that the matter be rescheduled to be heard at the same time as file number 19092 is scheduled before the task force. And that was a unanimous vote at the time. Okay, so be it as it may, I think, and Mark, do you think that we should do this by taking an action to make this adjustment of the agenda?
Is there opportunity for public comment on this item?
Let me just finish with the question, and if there is a motion that's going to be on the floor, then we will allow public comment then. Mark?
What would you entertain such an action to be? Like a motion to hear both as one sort of thing, or a motion to amend the agenda? Well,
just to include 19048 as per the orders of the task force. Because I guess the reason that both were to be heard at the same time is because they would, the result of what is being introduced today would have an effect on both of them equally, as Member Yankee had cogently put it. It's a process question.
Right. Sort of silently thinking here. It's one of those, I don't think it's necessary, but I also don't think it would hurt, because ironically, by making an action item, you're almost recognizing that it might be a bigger issue than it really is. Do you know what I mean? But just so everyone's on the same page, you can put it up for a vote and see that everyone agrees.
I'm kind of considering this to be somewhat of an, like an oversight error just on the creation of the description on the agenda, more than there be any, substance to it.
Might even make sense if the parties who are here to respond to the notice agendized item, if they have any issue or any concerns with hearing both at once.
Sure. Are the parties here? Mr. Barker and the zoo? The parties are not here?
It's Bill Barnes from the City Administrator's Office, if I could be heard on this briefly.
Are you going to be speaking on this case?
Correct. So the notice for this item was to have the City Administrator come present on the provisions of the lease, and we provided written comments, and based on the clerk's direction, are here to speak on that item, that limited item. I'm not as familiar with the other complaint, nor have I researched it. I don't think it impacts the City Administrator, but I just wanted to flag that we had been noticed, and so we're ready to talk about our part. I don't know about the other complaints that are related to it, because we hadn't seen the other complaints as part of the referral.
Okay. All right. Seeing that none of the other parties are here, and the information that we're most interested is from the City Administrator's Office. Members, what do you feel comfortable in doing at this point? Shall we have a motion to just add the item, since it's not substantial, since it's part and parcel to the same case, or just assume that they're together?
If I can make a quick comment, I was just looking at the attachments for this file number, which is 19092, and on page 17, that's the legal memo that goes along with it. There actually is a reference in there to 19048. So if one were to have read the entire background, all the attachments, if it makes anyone feel better about hearing them together, there is actually a reference to that.
Okay. All right, so the question is, this is a process question. Shall we make a motion to just add the file number so that it's clear what we're here to be doing today, or shall we just move on? So I'm not hearing any motions, so I guess we're just going to move on. We're going to assume that 19048 is part and parcel to the to item number 6, as per the narrative and the actions that were taken that are attached to this and that are contained in the documents. Okay. Anything else? I'll take some public, in the interest of the public has anything to say about it. No, seeing none. Okay, then let's move on. Cheryl, can you please read the opening statement regarding remote access?
Okay. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320 declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely, via Microsoft Teams, and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
And meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Okay, let's call the next item.
Item number 2, election of new vice chair.
Okay, so we're in need of a vice chair. Our previous vice chair, former member Josh Wolf, is no longer with us, and actually that seat is still vacant. I haven't spoken to anyone, but if anyone is interested, I would say the only additional work with regards to this position is for the chair to have somebody to consult with on matters pertaining to the operations of the task force and to take up any additional duties or help with regards to the overall management of the task force, and to actually also act as a default if there aren't enough members to sit on a committee, and to chair the meeting when the chair is not available. So,
Well, I'll volunteer some interest.
okay, great.
I was going to volunteer member Yankee, so.
Okay.
So was I. So we're
That's awesome.
on the same page. Who would like to make a motion? It sounds like.
It's okay to have a little competition. It's all right. If you really are interested and want to do it.
I will move to nominate Member Yankee as our new vice chair.
I'll second the nomination.
So it's moved by Member Hensy, second by Member LaHood. So just wanted, everybody to be cognizant, we should try to keep as much diversity as possible. But if everybody here is okay with it, we should forge ahead. Let's take is there any other discussion from members on this before I go to public comment? So I guess since you offered, you'll accept the nomination, right?
I'll accept it, sure.
Oh,
Yeah.
right, sorry.
Great. So I'll open it for public comment now on the motion to elect Member Yankee to vice chair. Okay, seeing no public comment, let's call the roll.
Member Hensy?
Enthusiastically, yes.
Okay. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. The motion to appoint Matthew Yankee as the new vice chair passes.
Okay, great. Welcome.
Thank you.
Matthew, you're already sitting on like 2 committees and.
Yeah, well, yeah, there'll be a lot, so we'll talk about that.
There's not, believe me, there's not a whole lot that happens. It's really more just consultation with you than actual physical work. So just take it from there.
Okay.
And if it turns out to be too much, then we'll figure out maybe on reducing your committee assignments.
Okay.
All right. Okay, great. Let's go to the next item, please.
Item number 3, inquiry regarding quorum under Charter Section 4.104.
Okay, the reason that this is up on the agenda is we got a letter from Mr. Winship Hillier that I thought was interesting because there was some, he points out some issues with regards to Charter Section 4.104. This also has to do with a little wider issue too. I mean, the task force also, how are we kind of fit into the different meeting bodies with regards to the charter. It's either, I think it's Article 4 of the charter. I think that's what it is. They call it. Yeah, Article 4. So Article 4 is specific to the executive branch. Okay, there is another section, Article 2, which regards itself to the legislative branch. And if we think about the separation of powers, then, what's in the executive branch area of the charter should not necessarily cross over to the other branch. It's written in constitutional construction in this way, so there's a definitive independent separation. You could also look at the third branch, which is Article 7, which is the judicial branch. So the question is for that Mr. Hillier brings up is with regards to the San Francisco Behavioral Health Commission as to whether Charter Section 4.104 is applies to it or not. And this has a kind of a precedent and wider ranging stance because it will also affect anybody else that brings up Brown Act concerns or complaints with regards to any number of growing commissions, advisory bodies, oversight committees. I mean, it's all different kinds of things and how they're created. Some are created by the vote of the by the voters. So how does that fit into the executive branch, or does it fit into the legislative branch? It's much like how we were created. The Ethics Commission was created in the same way. Prop I, which is still being determined, but that has another oversight body in it, created by the voters. It doesn't necessarily it doesn't necessarily direct it to be connected to one branch or the other, which I think should probably happen in the future. It should be specified in some way. So bringing this up for a little bit of discussion, because I think the task force should take a position on things that are other than policy bodies, and if they are policy bodies, how were they created? So that way it becomes very clear. We could send this kind of a memorandum out to the city so that they can figure out who they are and what they are, so that we don't end up with lengthy down the rabbit hole discussions about kind of interpreting the charter with regard to this. So is Mr. Hillier here?
I'm present.
I
Hello.
think I just heard him say he's here.
He is. Mr. Hillier, can you hear us?
I can hear you. Can you hear me?
Yes, we can hear you. Very good.
Okay.
I want to give you some time to make a brief presentation on this and kind of your kind of case about this based upon what you wrote us, and then maybe we'll have some more discussion.
Excuse me, Bruce,
Yes.
just before we get started, is this something you'd like timed?
No.
Okay.
Well, I'll try myself
He's
anyway.
here at my invitation. Go ahead, Mr. Hillier.
Thank you. Thank you, Mr. Chair. I'll try myself anyway. I don't want to take up too much of your time. I just add that the procedural posture, which this, how this comes before you, is a little bit strange because it was recently heard on October 27th in the Compliance and Amendments Committee, and there, I thought what had happened was that it would have been referred to a subcommittee to be heard on this date, and so I'm a little surprised that it's coming before the full board, because there was no motion to recommend either yay or nay from the Compliance and Amendments Committee. Also, the record has become a little bit incomplete. My initial query to the task force was not included in the agenda packet, and I just want to say you've covered some of it, but I want to add that this is attached to a file number 20100, a complaint against the Behavioral Health Commission, and that commission's bylaws, Article 4, Section 3.d, as in David, says, and I quote, "The quorum for a full board meeting is always 9 members. For the San Francisco Administrative Code, which states that a quorum is 51% of the number of members designated by law, rather than the number of seats actually filled. SF Administrative Code, Charter Section 4.104. End quote. So that's a little bit confusing. I don't think the Administrative Code has anything to do with it, but you can see that they actually don't have a quorum, and therefore not a majority of the members were present at the meeting about which I'm complaining in file 20100. And the reason is that they only have 5 members right now appointed with current appointments, and it's a 17-member board, so they can't possibly get a majority unless you count holdover appointments. So I don't think holdover appointments can count. So the city traditionally has counted holdover appointments as making up a quorum and also making up a majority for the Sunshine Ordinance. So, and I'd just like you to consider in regard to this, for one thing, Charter Section 4.104b says, and I quote, vacancies on appointed boards, commissions, or other units of government shall be filled for the balance of the unexpired term in the manner prescribed by this charter or ordinance for initial appointment. It doesn't say anything about or until a successor is appointed or anything like that. It says the remainder of the balance of the unexpired term, which means at the end of the term, it's over. You're no longer a member. It's also supported by case law. Kansas City Court of Appeals for Missouri, Justice Arnold wrote in State versus Brown, which is a 1925 case reported in volume 274 of the Southwestern Reporter. That must be Southeastern. I'm sorry. Or maybe it is Southwestern. Pages 695 and 965 and 968. And I quote, "We safety authorities uniformly hold that where an act creating an office provides that the incumbent shall hold until his successor is duly elected and qualified, the incumbent holds until the office is filled by somebody else." End quote. So it's got to be the case when the act doesn't provide that the incumbent shall hold until a successor is duly elected and qualified, that they don't. They don't fill the role. But, you know, the waters are muddied somewhat. For instance, Proposition B on the November 6, 2007 ballot added Section 4.101.5 to Article 4, and it said that the current practice was that basically holdovers continued to hold office until a successor was elected. I don't think there's any separation of powers issue here. All of the charter has to be passed by the voters. That's the only way to change or initiate a charter is through the voters. So they can say whatever they want. They can put whatever they want wherever they want. Article 4 has stuff in it that says, like 4.104 subdivision A, unless otherwise provided by the charter, the composition of each appointed board, commission, or body of any kind established by this charter or legislative act of the United States of America, the state of California, or the Board of Supervisors shall ... That definitely includes the Behavioral Health Commission because it was established by an ordinance of the Board of Supervisors. So there's no question here that parts of this Article 4 apply to legislative bodies such as the Behavioral Health Commission, which is not a charter commission and it's not an executive branch commission. Back to you, Mr. Chair.
Thank you. It's on mute. Members, I just want to just to state that while Mr. Hillier had mentioned various cases or files that might either be current or not, I want you to kind of overlook those and just listen to more of the thrust of his because that's really what I'm interested in ascertaining here. One of the kind of provisions in the charter that I'm really focusing on here in section 4.104 is in A, the very first line. It says, unless otherwise provided in this charter, each appointed board, commission, or other unit of government of the executive branch of the city and county of San Francisco shall, and then all the other provisions that come in underneath it. It does not specify other branches of government, whether it be the legislative branch or the judicial branch. As I said in my opening statement here, the Article 4 is specific to the executive branch, and there shouldn't be any crossover. If there is, then that is serious constitutional conflict in the way that the charter was written. So this is also kind of the rub that we as a task force also get thrown into, because we were not created by the executive branch. We were created by an ordinance that was created by the voters. So that's the question. And when you look at the legislative branch also, they don't really have that many, if any, meeting bodies or appointed boards or commissions that come under them. Everything, because they have authority to do a whole lot of things. They can create ad hoc committees, which they may have from time to time, but there isn't really any boards or commissions that they actually create that are underneath their in their kind of authoritative jurisdiction, compared to the executive branch, which creates all kinds of things because it deals with the operations of the government itself. So I'll stop there. I want to open it up for a little more discussion. I don't want to spend too much time on it, but I think at some point or another, we're going to have to kind of come to some sort of position to create some sort of kind of condition that we can stand on as more and more cases come up with regards to these growing either created bodies by whichever branch of government or the voters. I'll stop there.
Chair Wolf, I have a question that's related to this, although it has not specifically come up in this, but since we're talking about this topic. So there's
Sure.
the definition of quorum, and then how many votes are needed for something to happen, as with the Sunshine Ordinance Task Force and what we've run into with needing a majority of the total number of seats. Do we want to get into that, or do we not want to get into that part of the discussion?
But that's part and parcel of all of this. Is when you look at B, that's section 4.104B, and it's just the first sentence. I'll read it. The presence of a majority of the members of an appointed board, commission, or other unit of government shall constitute a quorum for the transaction of business by such a body. So now when you compare A and B, A says other unit government of the executive branch. B does not have the words of executive branch in there. Was it the intent of this is now not the framers, so to speak. The charter was rewritten in, I think, 1997, 96, 97, I think. The question is whether, because when you look, it's in Article 4. It's under boards and commissions with regards in Article 4 under the executive branch. Paragraph A states other unit of government of the executive branch, and B says just other unit of government. So do we take it on its face of what it says in the letters on the page, or do we take it as part of its intent? Now, the question, if we take it upon intent, then, and we mean that paragraph B means appointed board, commission, or other unit of government of the executive branch, then that makes a clear distinction between whether it's executive branch, boards or commissions, or other units of government. And if for the executive branch versus the legislative branch or judicial branch, and I don't know where the voter approved ones fit in. I guess the voter approved ones fit in based upon where they're placed in either the codes or in the charter. And if they're placed in just some general code, that applies to them, then we have to determine whether that code is part and parcel of the executive branch or the legislative branch. So if you can kind of get my complexity here, what I'm presenting as complexity, this has been a long-standing level of confusion, because on top of that, when we talk about what Mr. Hillier was referring to as holdovers, where there's a vacancy, so where there is like the end of a term of a board or a commission, and there hasn't been a replacement, the person who's currently there is held over. And for city boards and commissions, I believe it's 60 days. But that came up during the Sunshine Task Force consideration in 2014, where it was deemed by the city attorney serving the Board of Supervisors at the time in a public session that, for example, the Sunshine Task Force, because it was elected by the voters, doesn't apply to Article 4 because it wasn't created, it's not an executive branch body. So it follows state law, and state law has no limit. There's no 60-day rule, 90 days, there's no day rule. The holdover can be there ad infinitum if no replacement has been made. And I'll stop there.
Member Highland here.
Yeah.
I think this is something maybe we should open a file on and kind of look at, over some weeks. I don't know if we're ready to take a position on it just yet. I mean, I have some ideas of where I think it should go, but I think that might be a reasonable first step. Maybe even get the city attorney to weigh in on some of the legalese supporting this. I remember I think it was a Board of Supervisors meeting where John Cote opined on this. I want to dig into that a little bit to see what he thought we were. That would be interesting reading about 3-4 years ago. But yeah, it definitely, I think how we define ourselves will either give us a leg to stand on or not on certain issues. So I think this is important enough to perhaps assign it 1 or 2 people to dig further, maybe bring it back to the full board.
Yeah, that's fine. I think that's reasonable. I mean, we could assign it, refer to a committee to further research and review too. Any other thoughts?
I have a question for Mr. Hillier. Is that appropriate?
I'll allow it as long as it doesn't apply to any cases. If it's just applicable based upon his thoughts on the merits with regards to the charter, that's fine.
Yeah. Well, just as to the case that he cited, I think he said it was a 1924, 1925 case coming out of the Midwest. Is that a situation, Mr. Hillier, where you were looking for something on point and you felt like that was the best thing you found? Or is there some other reason why you cited a case from that place in that era to us?
Thank you. To respond to your question, I pulled it up because it seemed applicable. And a lot of times when you look into very basic issues like this, you have to go back in time quite a bit because they're just not litigated anymore recently because they've been resolved. And so it happens to be an old case, happens to be out-of-state case, and it was just the first cut on my research. Back to you, Mr. Chair.
Thank you.
DCA Wolf, do you have any thoughts on this? It's not required at this time, but if you might, if you have any thoughts?
So you and I looked into this when the issue of the holdover came up. We had some emails going back and forth.
That's right.
And I definitely think it's worth doing a deeper dive into the legal analysis for the whole committee, the whole task force to see. I'm happy to do it in the first instance, or if, Member Highland wants to take a crack at reading through some of those older minutes, and then we can powwow about how to frame it. But I think there would be multiple benefits for the task force to have like a unified understanding of this issue, not just on quorum, but on the holdover issue. And it comes up, it's not so esoteric that it's just an academic discussion. So I'm happy to look into it, or I can wait until you guys do a little bit more work and I can look into it, or we can craft it together. I could work on what the exact issue to craft is, but I don't have a set answer right now because I know we went back and forth a bunch, a few months ago. So.
Yeah, I would also note that section 4.104B, that was added because there was one or more members of the Board of Supervisors who were on maternity leave, but they wanted to continue to participate by teleconference, and there's a whole section in there with regards to childbirth and other needs with regards to adoption or foster care or what have you. So that's why B was actually put in there. And I also want to note that it was regard to teleconferencing, there was also some law change in the Brown Act with regards to that also. So it was kind of in alignment with that. Okay, so shall we have, do folks want to volunteer to work on this issue, or shall we refer it to committee and then have DCA Wolf kind of work with you guys on it? You want me to make the decision? Okay. Let's see what we got here. Lila, would you mind taking this on in your committee, considering it's kind of amendments oriented in a way?
That is fine. We can do that.
Or compliance and that kind of thing?
Remind me, and forgive me, Member Highland, are you part of this committee any longer, or would you still like to make those contributions even if you're not?
Good question. Yeah, I'll be happy to weigh in. I'm not sure if I'm a member of that committee or not. I'm chairing EOTC right now. I think that's all I'm on. I could be wrong. I think.
Can I say something?
Yes, go ahead, Cheryl.
The members of the compliance committee are you, Lila, and Matthew.
I thought Jen.
I'm sorry, it's Jen. It's Jen. It's Jen. The three of you.
So again, it's Member LaHood, Member Wong, and who's the third?
You.
Oh, me. Okay. All right. Well, that's fine. Member Highland, if more than welcome to join in on that discussion when it comes up on the agenda. Love to have you and anybody else if they want to be part of the discussion and see what we can pull out of it.
Can I ask another question?
Sure.
Is this something Lila would like to include in our next CAC hearing coming up this month? I've given her an agenda with 5 cases, but if you think this is ready for discussion before CAC, I'm happy to adjust the agenda.
I think we need some additional research.
Can we take this off? Can we take it offline? I don't need to discuss this during the meeting here. You can just, 2 of you can just work together on developing that in the agenda. I appreciate it, so we can move on with our agenda here. Thank you. Okay, let's open it up for public comment. I don't think there's really any action at this point, so let's open it for public comment.
Hi, my name is Lynn Shapiro. I'd like to make public comment.
Sure, go ahead.
Thank you.
Go ahead, sir.
Thank you. Yeah, I just wanted to clarify. Yeah, Proposition D in the November 7th election of 2006 did significantly add to Section 4.104B. But I do believe the section was there beforehand. It just didn't have all of the stuff about maternity leave and participating in teleconferences, which are otherwise disallowed under the Sunshine Ordinance. Back to you, Chairman Vogt.
Thank you. Any other public comment? Last call for public comment. Okay, seeing none, the item will move to Compliance and Amendments Committee, and Chair LaHood and Administrator Cheryl Leger will figure out the time when it will be on their agenda. Okay, let's call the next item.
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda. And it's 5 o'clock on the dot right now.
Okay, great. Any public comment? Not on our agenda today.
Yeah, my name is Swin Shapilier. I'd like to make a public comment.
Can you hang on a second, Mr. Hillier?
No, this is general public comment.
Yeah,
correct.
I understand.
Right.
Go ahead, sir.
Okay, thank you. Thank you, Madam Clerk. Yeah, just 2 notes on procedure. You know, I don't want to barge in on you guys and tell you what to do, but when you refer something to a committee, normally under Robert's Rules of Order, that requires a vote. And there was something else, but my mind is blanking. I can't remember what it was. I'm sorry. Back to you, Mr. Chair.
Thank you. Any other public comment? Okay, last call for public comment. Okay. No other public comment. Public comment is closed. Let's call the next item.
Item number 5, file number 20118, discussion regarding the San Francisco League of Women Voters idea to create a one-stop shop to post agendas and meeting announcements.
Hey, did former member Luam testify?
Yeah, she accepted an invitation.
Is she
I
here
sent her
today?
one.
You didn't get an RSVP from her, did you?
I believe she accepted her invitation to the meeting. I sent her one.
Okay. Former SOTF member testify, are you here? I don't think so. Member Wong, are you familiar with this?
I'm very vaguely familiar. I had sent an email to member Testify when I was taking over, but she seemed to say that it was already in process and nothing else needed to be done.
Okay, just wondering if you had any information you wanted to make a presentation, because this comes from the League of Women Voters. No, okay, fine. Well, it's in the agenda. Everybody had a chance to read it. This is based upon some of the work that we did at near the kind of in the middle of the pandemic period over the summer, with regards to Supervisor Sandra Lee Fewer's resolution regarding more transparency around meetings and other information for the public. Basically, the idea that came up was to kind of find a way to make a recommendation for implementation of Supervisor Fewer's resolution. And we decided to take it upon ourselves to try to create something. So So this is it. The purpose of it being on the agenda today is to I accept it as is, or to make adjustments to it, and then to forward it to the Board of Supervisors. And probably I probably will forward it to Supervisor, maybe Supervisor Fewer to introduce it.
It looks pretty comprehensive from what I can see. I like as is.
It seems as though, we had a lot of discussions on this matter early on, and this seems to incorporate all our collective requests very nicely.
Any other comments?
Go ahead.
Go ahead, Member Yankee.
I was just going to say I agree with Member LaHood.
Okay. All right. Is there a motion? And then we'll call public comment.
I'll make a motion to approve this memo and to send it to the board.
Okay.
I'll second.
Moved by Member Long, second by, I think that was Member Highland, yes?
Yep.
Okay, great. Any other discussion on the motion? Let's move to public comment. Public comment on the motion. Any public comment on the motion? Last call for public comment. Okay, hearing no public comment, are we ready for a vote? Please call the roll.
Member Wong?
Aye.
Member Wong, aye. Member Highland?
Aye.
Member Highland, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Vice Chair.
Member I approve. I apologize. Vice Chair Yankee. Member LaHood?
Aye.
Member LaHood, aye. Member Kinsey?
Aye.
Member Kinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to move this to approve the memo and send to the Board of Supervisors passes.
Okay, great. We're going to, we could send it to the president of the board, but I think we'll also send it to Supervisor Fewer, just to respect her original introduction of the resolution. She so wanted to make the introduction at the Board of Supervisors. It's kind of how they work. Okay, let's call the next item.
Item number 6, file number 19092, complaint filed by Justin Barker against the San Francisco Zoo for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay. So we have I think Mr. Barker is here, correct?
I'm here.
Okay, great. And City Administrator here?
Yeah, Bill Barnes for the City Administrator.
Okay, great. Okay, so this is part and parcel to two cases, 19092, which is here, and 19048, which is similar to it in the same way. They're both part and parcel to each other. The question here is with regards to the contract of the zoo with the city, and whether the zoo is required to comply with sunshine. The zoo has cited various other codes that regards to the withholding of veterinary records with regards to animals. The task force had basically denied that defense because it was deemed that was meant for private citizens and not for city government. Since the zoo is under a contract as a subcontractor or a contractor with the city, and the city owns the zoo, owns the animals, owns the whole operation pretty much, and hires the Zoological Society to operate it, it would seem from us that we feel that anything that happens within that department would be public information unless there was other citations of law that prevents the disclosure, which we have not heard about since then. So considering that we had asked the Zoological Society to provide information with regards to this, and they were pretty much we're not going to disclose the information despite our order. We wanted to hear from the actual agency or department or the city official that manages and oversees city contracts to help us provide us with information to help us make further decisions on this matter. So I'm going to call on the city administrator now to provide us with whatever information you can.
Chair Wolf and members, thank you for that. So the city administrator is not the contracting agency with the zoo. So under the city charter, the Recreation and Park Commission has the authority to enter into contracts for their property, and that is sort of independent and owned by the Rec and Park Commission. I believe in 1993, based on reviewing the file, that they entered into a contract with the Zoological Society. So my understanding of the provisions that were discussed in the city attorney's memo, the department that has the contract is responsible for ensuring that the public records laws are maintained. So if the city administrator, for example, had a lease with a different organization in a different context and someone came to ask for records, then we would be the folks responding to those records requests and complying with all the different requirements. Here, because the agreement was entered into by the Rec and Park Commission and they have their own charter authority, the city administrator has no approval in that process. In addition, Chapter 12L says that the contracting or awarding department is the one where there's a complaint and to follow up with. So I think you raised an interesting question, and I think the deputy city administrator's memo on this topic was fairly thorough. But in this particular instance, the city administrator isn't the agency with the contract.
Okay, so a couple of things. One is, doesn't the city administrator have an office of contract, like compliance or oversight?
The office of contract, not to interrupt.
Go ahead.
The Office of Contract Administration, also known as the purchaser, generally oversees commodities and supplies. When you're talking about real estate agreements, which is essentially what this is, there are certain agencies in the city that have unique charter authority, including the MTA, PUC, Rec and Park, Port, Airport, to engage in those sorts of contracts. And then the final decision maker for those would be their commission.
Considering that the Rec and Park Department is a city department under the executive branch, isn't there some kind of oversight on contracts to bring them to form, either by your department or a city attorney or something like that?
I would concur. The city attorney contracts to form for all city departments and make sure that all the provisions that are included meet the laws of the city. So I believe, and I don't have the document at the ready, but I believe the city attorney approved this contract as to form and would be one of the city actors who could enforce provisions of it.
Okay, and I'm curious as to why you cited 12L.
My understanding was that there was an issue around records for the nonprofit, and that section of the code refers to if you're seeking records that are not city records but are records held by a nonprofit organization. Those provisions would be incorporated into contracts generally. So when a nonprofit organization like the Zoological Society contracts with the city, they agree to certain requirements around records and meetings. Those terms are incorporated into the contracts, and every department does that to make sure that there's a way to enforce on it.
I hear you. I'm a little kind of somewhat in disagreement with that, because this is a city contractor that is providing a service to the city that the city would or could normally provide its own staff and resources for. Like, for instance, in fixing the sidewalks or things like that. Those contracts for those kinds of things would not come under, even if it was, whether it's a private for-profit corporate business or a nonprofit, they wouldn't be subject to 12L provision. 12L is more or less for operations that the city wouldn't be. They would provide a grant or a lease or a loan of some sort, and all those things are classified as quote-unquote contracts. We've had some cases, like, for instance, around the Bayview Opera House, where that is not a city-run facility. It's not a city-owned facility, and but there are grants and other contracts that are provided to work with the city to operate it. They fall under 12L because they have a specific singular contract for something. The Zoological Society does, in our eyes, didn't fit that same model.
I respect the disagreement. I would just note that the cultural centers like the Bayview Opera House or Mission Cultural Center are owned by the city. So the city actually owns the property and real estate, and Public Works manage and maintain it. And then there's a nonprofit that operates the services that are offered in those facilities. But I understand your earlier point that these are folks providing services that city employees could otherwise provide, and I think it's a good one.
Okay, thank you. Okay, members, I'll leave it with you and at this point, and if you have any more questions for either the city administrator or for Mr. Parker, I think our own legal counsel, DCA Wolf, might have some more information for you also. Have at it.
If I may, Bruce?
Go ahead.
Just for those new members who kind of are coming into this case, just to kind of point you to the part of the contract that I think, speaks to this. So if you look at your agenda, it's page 66, and it's section 16.2 of the contract. This contract seems to have some rather unique and very specific language about how the Sunshine Ordinance may apply here. And I'll just read like the sentence here that I think is pertinent. It says under public access to records and information, it says the SFZS shall provide public access to information concerning the operation of the zoo to the same extent that such information would have been available to the public pursuant to local ordinance if the department had continued to operate the zoo. So I think that's a pretty, all-encompassing application of the Sunshine Ordinance to this case. And I know we've seen perhaps some other contract cases that doesn't necessarily have this very specific language, but this one does. And so I think that's why we've made our prior rulings that, obviously Mr. Barker here is searching for specific records and, submitted a Sunshine request and hasn't received those records. And I think that portion of the contract rather explicitly says that he's entitled to them. So that's just some background.
This is Member Wong. Thanks. That's very helpful because I was kind of going through the contract and I was like, I hope they point out the section that applies.
Yeah, there's a lot to go through.
Yeah, thank you.
Is anyone here from the, on behalf of this is Member Schmidt, on behalf of the Zoological Society?
No, I don't think, I think the only party from the city that's here is the city administrator. And one of the issues around here is that we've asked for, we thank the city administrator for appearing and for providing us with their memo. But the Rec and Park Department has declined, and it's ended up being somewhat of a political football at this point. So if the city administrator is, as they're stating, does not have constitutional authority to oversee this because the Rec and Park has the charter authority to oversee their contracts, then I think if we're needing more information, then that's where we need to go.
Yeah, I just had a couple of questions I wanted to ask someone at the zoo and see if they had any answer to me. And I do see how, yeah, Rec and Park is the responsible agency probably here.
Well, if you think your questions are worthwhile, why don't you put them on the record, and then we can maybe DCA Wolf can answer it, or maybe even the city administrator may have some information if they're interested in chiming in, or it may lend us to want to think that it's important enough to compel Rec and Park to appear.
Well, I think my questions go more toward somewhat of a secondary issue in the case, which is some of the assertions made by the Zoological Society about privileges and privacy that are fairly vague, and I wanted to see exactly what their basis was for those. But since they're not here, I can't get those answers, so I'm gonna hold off on that.
Okay. I also want to note that the other defense that the Zoological Society brought forward is that they provide any and all information directly to the Joint Zoo Committee. And so the Joint Zoo Committee is it's a city body. You know, there is also that entity. And I don't know, I haven't followed it, I haven't actually researched it to determine, you know, if they meet regularly or not.
Remember, Chair Wolf,
Go ahead, Member.
the petitioner, Justin Barker, could he make the same request of that committee and therefore bypass the?
He's here. He's here. Do you want to ask him?
No, I know he's there, but I'm asking, would that help him get the information he needs, if indeed that is a bona fide city body, and the society is beholden to them? If you ask them for that information, the society can preserve its so-called privacy and whatever, and provide that information because that company is requesting it. Is that a good workaround?
Well, my only concern about that is that the Zoological Society might declare the same defense in refusing to provide the same information to the committee itself. And then what the answer that you'll get from the committee is, we don't have that information because Zoological Society refuses to give it to us. And then what? We're back to where we are right now. So it's worth the inquiry, but I don't know that it necessarily gets to the heart of the matter here.
Okay.
Yeah, Vice Chair Yankee, go ahead.
Yeah, just to kind of address Member Schmidt's questions here a little bit. We already went through, just to update everyone who's kind of coming new on this, that we already actually went through the process of finding a violation. The zoo did appear initially. I think they've subsequently, refused to appear. So this is more of an enforcement issue now at this point, more than, are they in violation or not in violation. So we've already had that back and forth with the folks from the zoo and have asked, I'm not sure if we asked that particular question, but I know we had a lengthy discussion and they raised a variety of reasons why they thought this was privileged information, shouldn't be turned over. And the task force subsequently decided, no, I mean, they do need to turn this over. And so I think the part that we're at now is finding out how to enforce our orders if there were violations and that, Mr. Barker is entitled to respect. It's more enforcement question, I think.
Right.
Chair Wolf, I mean,
Go
at
ahead.
this point, it seems as though we're going around in circles with them because we found our order of determination and they continue to insist that it doesn't apply to them. So perhaps we need to refer this to ethics, specifically citing that paragraph in the lease and saying it clearly does apply to them. And they're being not responsive to this.
Okay.
And should it go elsewhere? I'm wondering, or do we want to? If we forward it to more than one body, they'll just keep passing the buck. So maybe we should really zero in on where we do want to send it.
If I could, Chair Wolf, it's Bill Barnes. I'm happy to try to assist the requester in getting the records. I recall a similar circumstance a number of years ago where PETA was looking for records from ACC and they petitioned the supervisor of records, who I think is in the city attorney's office, and then certain records were produced. But I would need to go back and look at my files. So, I understand the enforcement problem that the task force is having, and I'm happy to look into it and report back if that would be agreeable to the requester.
Mr. Barker?
Yeah, my goal is to get the records. So however that can be done, great. My hope is that whatever steps are taken, that if the zoo still refuses to hand over records, that there's kind of a next step. So I'm happy. I've been at this for 2 years, so I'm happy to kind of continue down the line. And my goal is to get the records done. So obviously, you have a really good understanding of what steps need to be taken. So I would kind of leave that to you. But my hope is just there's some accountability and whatever avenues we can take to get hold the zoo accountable. And
I have another thought. The contracting agency here is the Rec and Park Department. Really ultimately that they are, they're kind of responsible for the production of the records with regards to this. And if anything, they're responsible for the enforcement of the contract. And the contract to us is very clear. So I think that, and correct me if I'm wrong, Rec and Park declined to appear.
Yes, that's correct.
Okay. Compliance and Amendments Committee Chair LaHood, they refused to appear at CAC, right? Is that correct also?
That is correct.
Okay. So I think, leaving it on to the Zoological Society and not the authoritative body that actually they're in contract with, who owns the zoo, and all the animals and assets contained therein. I think it'd be incumbent of us to maybe send a letter to the Rec and Park Department with our order of determination and the reasons that we came to this conclusion. We'd appreciate any help from the city administrator on this. That would be equally helpful if helping Mr. Barker. But in the case, in the situation of complying with the ordinance and having this contract in front of us, I think it's compelling. Maybe we do something like that. Unless Member LaHood, you want to take another crack at trying to get him into a meeting.
No, I like the idea of sending a letter to Rex and Park with our order of determination, citing the relevant paragraph in the lease, and requesting their compliance, and then if we don't get compliance, then we want to see them back.
Okay. Now, I don't think that we should leave the point that you had made about enforcement that you remember Vice Chair Yankee had brought forward. I think that maybe there should be some sort of enforcement implementation of some sort, either now
such as
or
that we want them to report back by a particular date.
well, it could be by that, and then if they don't, then what? And if they do, then what? It's I think we're asking them. The order has been made that the information is public, and that it should be made. This is whether they fall under 12L or the ordinance or what have you, doesn't matter. The government code that they're citing, not code, the business and professions code that they're citing, really applies to the private sector and not the public sector. And if the Zoological Society is going to resist providing that information, then it's incumbent upon the city to provide it. And if the city wants to make hay about, the same business and professions code, well, then it's a different story. Come to the task force and make that argument. But if the contractors is not willing to be compelled to produce the documents, then I think, we have to then at least offer up that we're going to take this seriously.
If I could add one piece that may be included in that, but since Mr. Barker's here, again, this is Member Schmidt, it seems like what we're looking at is the Zoological Society has potentially, and this is the order, they have an obligation to act. And then there's somewhat of a parallel obligation where Rec and Park, if they get a request from Mr. Barker, they then have, from what we've seen in other cases, they have an affirmative duty to go out and find their contractors and make the request to them and say, look, we got a request from somebody and we need you to give us these documents. And they're going to have a certain obligation, I think. And so it's their affirmative action of going to them. And so that's what I think Mr. Barker probably has already told them, you got to go out and get this. But I just want to make sure that's included in everything we're talking about here.
Is there an action? Is there a motion that we should take at this point?
If I may.
Go ahead.
I think Member LaHood's, I think she summarized it pretty well. I forget the exact wording that she used about writing the memo to Parks and Rec, asking them to enforce this contract. And then I would add, and then I'm open to how long that we would expect a response back in X amount of days. And if we don't receive that, then we will refer to the Ethics Commission for further enforcement efforts. But I think Mr. Barker's been waiting well over a year for this, and so I think we need to make this, we not just make an open-ended time frame for Parks and Rec to solve this, but make sure that it happens rather quickly. And if it doesn't, then we move to the next stage of referral.
Okay.
That sounded like the beginning of the motion there.
So I guess I can make that as a motion. I'll move to write a letter to the Rec and Parks Department asking them to enforce this contract and our orders related to it within 30 days and report back to the task force. And if they don't, then we will refer it to the Ethics Commission.
I would ask that maybe it not be 30 days.
I'm open.
I would ask that be 14 days.
Sure, 14 days. Yep.
This case has been on our docket. They've had opportunity to and had invitation to come and speak to us. I think it's worthwhile to, they've had plenty of time.
Works for me.
Okay.
Maybe
Is there a second?
I'll second, and maybe specify 14 calendar days, just so it's crystal clear.
Sure, 14 calendar days.
Okay.
Second.
Any discussion on the matter, on the motion?
Just that we make sure that we cite the specific paragraph from the 1993 lease so that there is no confusion about whether this does or does not apply.
I think that's a great idea.
16.2.
Yep, 16.2.
Can you just tell me what page it is so I know and I can look at it?
Page 66.
I'm sorry, what?
66.
Okay.
Like Route 66.
Okay. Any other discussion on the motion before I take it to public comment? Okay, let's call for public comment. Any public comment on the motion? Calling for public comment on the motion. Public comment on the motion. Last call for public comment. Okay, hearing no public comment, please call the roll.
Member Yankee?
Aye.
Vice Chair Yankee? Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Member Highland?
Aye.
Member Highland, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion to write a letter to the Rec and Park Department passes.
Chair Wolf,
Yeah.
I'm sure we'll do this, but just wanted to note it'd be nice to maybe include the original IDRs along with the letter so they know exactly what they're asking their contractors for.
Sure.
And I'm talking about 092 and 048.
Yep. Yeah, we'll do.
All right.
Absolutely. Okay. I want to take a moment. Former task force member Luam Tesfaye arrived. We tended to go a little quicker because we didn't have much public comment. But maybe if we could take things a little bit out of order here, and kind of circle back to the just item 5. Give her an opportunity. Just maybe introduce that we approved the your submission and for it to be sent to the Board of Supervisors in its current form with no changes. But we would certainly enjoy anything that you would want to say about it or offer at this point. If there's no objection from members, we can do that. Then we can have her say, and then be on her way, because I know she's very busy. Okay, member testify?
Good evening, task force members. Can you hear me?
Yes, but there's an echo.
Phone though. Is your phone also on? Is it echo?
Yes. Let me try and mute that. Okay, is that better?
Yes, much better.
Okay, very good. Well, good evening, all of you. Nice to see you. I'm available if you have any questions. But I'm pleased to hear that you'll be using the memo and for any other purposes. I apologize. I'm having some audio issues.
We can hear you just fine. So just speak normally. Just speak normally.
Okay, I'm going to turn down the audio on my end. But I'm pleased to hear that you'll be able to use the memo. Does anyone have questions? No? Okay, great. I was just appearing at Cheryl's request, so I don't have anything additional to contribute, and I'm glad that it's helpful.
Great, thank you. Really appreciate your time and effort and the League of Women Voters, in putting this together. It's so important at this time, considering we don't have an end date of when shelter in place will be over. So, anything more that you or the League has to offer, either through Member Wong here or yourself, please feel free. Really appreciate it.
And I just wanted to say that I did reach out to Allison Washburn before I prepared the memo. And so Jen Wong or Member Wong can always reach out to me if she wants to brainstorm on any issues as well.
Okay, great. Thank you for your time. Really appreciate it. Good to see you.
Good to see you too. Have a good evening, everyone.
Okay. All right. Take care.
Bye.
That was your shortest meeting ever. That was awesome. Oh, she missed it.
She did. I'm sure she heard it.
I heard
Okay.
it. I heard it.
Okay.
All right, great. Okay, let's call our next item.
Item number 7, file number 19076, reconsideration of Sunshine Task Force findings. I will read the preamble. On February 5th, 2020, the task force found that animal care and control did not violate Administrative Code Section 6721B by failing to comply with the request of the petitioner to transmit the requested records to a specific email address. The petitioner requested that the matter be reconsidered due to new evidence. I do want.
Go ahead.
I was going to say, I just want to remind you that the petitioner did request a postponement. It was her second request. And I did get an email from 2 members of Animal Care and Control, Justine Alberto and Virginia Donahue, who both said that they were going to be on vacation this week. I received that memo Friday afternoon.
Okay, members. And I don't think any of the parties are here, correct? Any parties to this item?
Is
Number
this?
6? Yes, this is the one from the last meeting. Just a couple of weeks ago. Where we decided to continue it. So the question is do we want to continue it further since nobody's here? The parties aren't here. I mean, this is on a question of whether it should be whether did we agreed to reconsider it at the last meeting.
This is Member Wong. My understanding was that the motion failed, actually.
I thought so too.
For this one, yeah.
It was 5-2. So therefore,
Oh, it was 5-2. Okay. The motion. Okay. And I think this was put on there before the. I think we created this agenda before that meeting. And so it's still there. Okay. All right. Well, then I guess since we did not,
How do we deal with that administratively?
well, it's just got placed on the agenda, kind of not erroneously, but in preparation that if there was going to be a positive finding to reconsider it, then we would immediately, because we had this meeting coming, we would just immediately hear it. That's all. Okay, then I think, where are we at the end? Are we at the end of our agenda here?
This is the last case.
Yeah.
There's item 8 and item 9. Yeah.
Okay, then let's call item 8.
Item 8, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Hey, members, floor is open.
Chair Wolf, this is a request, I guess, for you, Cheryl. I don't know if it's possible in Microsoft Teams when you put out notices. If you could include in the title of the notice what meeting it's for, the date, because when you look at this on your phone, you can't get to that information. I can't actually open up the attached meeting notice and see what it was for. I have to get back to my laptop to look at it. Is that something you can work into the subject line, perhaps?
Are you talking about when I send out the link for the agenda?
No.
I do try to include. For when I set up the meeting.
I can answer that.
And send out invites.
This is Victor.
Oh, hi, Victor.
This is Victor. That can be added to the notice. When we create the title, we can name it with the name of the meeting and the date and the title.
Right. All it says right now is Sunshine Ordinance Task Force Special Meeting, and then you have to actually open.
We can add the date to that.
Okay, that'd be super. Thanks.
Thanks,
I'm
Victor.
sorry, you guys. I thought that date was already included when I set up the meeting, because I put in
it's just
a date.
in the title. Just add it to the title also.
All right.
Just add the date to the title also.
Okay.
This is Fiona. This is another, sort of Teams question. I noticed that a couple of our petitioners were joining us today, and invited guests were joining us today on Teams. Is that gonna be a practice going forward now, where the public joins us on where the parties join us on video?
If they are party to the case, and if they're invited to provide certain information that needs to be shared.
Yeah, because I noticed that our complainant in the last file was with us on today, and that was
that's the first time.
Yeah.
Yeah.
That was, so
I'm really trying to find a way to make Microsoft Teams work as best as possible. If we were in the chambers and people were sitting in the audience where they could see us. It's not an easy task right now the way it's currently set up. So my thought was, at least for the parties should at least be have the ability to see us, and if there needs to be a shared screen for us, then that be. I know it's not going to be applicable necessarily for the public who are on the phone, considering this isn't streamed. And that was my other question, was whether this could be streamed or not, to like YouTube or Facebook Live or something like that. I mean, I certainly could do a screen recording, so to speak, and stream it that way.
Yeah.
You know,
Yeah.
but
No,
yeah.
I like it. I was just noticing it today for the first time. That's all.
That's right.
Yeah.
So it's just trying to get as close as possible. I mean, this is not an easy platform, the way it's designed. So, anything else for the good of the cause in this item here? Okay, any public comment on anything discussed in this item? Seeing no public, let's call the last item.
Item number 9, adjournment. I have
Motion
5:49.
There a motion to adjourn?
Perhaps the new vice chair should make that motion.
Chair, I'll move to adjourn.
Moved by member Vice Chair Yankee,
Second.
second by member Hinty. All those in favor, say aye.
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 All right.
We are adjourned. Thank you.
Member Schmidt, this is a record.
Yeah, exactly.
Thank
Get
you.
used to it, huh?
The other way.
That's why they call it special.
Thank you, Mark, for attending also.
Thank you. Good night, everyone.
All right, folks, have a good night.
Good night.